Good morning, everyone. Good morning. Good morning, Instagram, YouTube, Facebook. Good morning. I'm just going to wait for you guys to tune in. What's today's date? Okay, today is the 9th. All right, let me just put in my phone number. Good morning, D. Castillo. Never say never. Good morning. Joan Stewarts. Good morning. I'm going to put my phone number in here and then we can just get started. Today, I want to kind of talk about some of what I've been observing with marriage-based cases, and some of the consults we've been having, what we've been seeing. So just give me a second. I'll answer your questions. Let me just put this phone number in here. So hard to type with the small screens. And okay, there we go. All right. Good morning, everyone. My name is Aisha Chidole. So I'm an immigration lawyer here in Atlanta, Georgia, but I present clients all over the United States with their family immigration, humanitarian-based cases. We also handle removal proceedings, or if you are in detention, we've had a couple of good news over the last few days, so that's great. And we'll keep watching to see how these immigration good news, how it goes. As we find out more, I will definitely update you. If you want to schedule a consultation, call our office, 678-325-1037, or you can also call 678-233-2170. If you want to use WhatsApp, we don't take calls on WhatsApp, but you can send a message with your number. So 404-333-8751. If you're on Instagram, it's pinned right there, so you can save it, or you can schedule a consult yourself with the link in our bio. If you're on YouTube or Facebook, you can see the numbers scrolling through the ticker, and the link is in our bio as well. Shar is asking, is consultation free? No, our consultation is $150. During the consultation, we typically are evaluating your immigration history, and we are also evaluating based on your immigration history, what you've sought consultation for, what you might be eligible for now or in the future. So usually our consultation is one of value. People don't, sometimes people say that, sometimes like they go into a consultation and they didn't really feel like they get it. But my job in consultations, just the same way that I come to you guys here without even really knowing your stories, to educate you. The whole purpose of the consultation is to educate you on all the different options that you have. What are the things that you need to do to prepare to make sure that you have a viable case or a winning case? Sometimes some people will consult even before they get married, just so that they know what it is that they're going into, or i.e. they're an LPR, married to another LPR, should they be filing, or whatever it is. So the consultations offer a lot of great value. And to me, I think that's always the best option for most immigrants who are wondering about their process versus online, because a lot of times, I come on here and I do lives, without really knowing you guys, knowing your immigration history, knowing anything about you really. So I'm just giving you like a very basic answer based on all circumstances being equal. But for a lot of people, all circumstances are not equal, and there's usually a lot more that we discover during those consults, and those consults help us to be able to, either say, okay, this is potentially an issue, but this is how you overcome this issue, or things that they think is an issue, it's actually not an issue at all. So that's why that's the value of a consultation. Today I wanted to talk about, I wanted to talk about just kind of some of what I'm seeing, like from some of the consults, that people come asking us to help them with a notice of intent to deny or request for additional evidence. We are seeing like a very thorough check on your B1, B2, or initial tourist visa from whatever your home country is. I don't know if you guys are not aware about that, but a lot of times, whatever it is that you wrote in your tourist visa, whether it was 10 years ago, 15 years ago, when you applied for an initial visa to come into the United States, I'm not sure if you guys know that those things are actually placed as part of your review when you are seeking a benefit here in the United States. So, for instance, if you're going for a marriage based case with your current spouse, USCIS will be pulling up your consular interview for your tourist visa, which is also known as a B1, B2. I'm just using that since that's the most common visa. And they're going to be looking at not only what you have in the application itself, they're also going to be looking at the consular officer's notes to see what is it that you said in the consulate interview that are in the notes that are not necessarily in your application, because they are going to be trying to connect the dot to make sure that the dots all match. So sometimes people, say, oh, an agent filled out this visa application for me. I have no idea what it is or whatever the case is. But it is really, really important that, especially, and this is especially for those of you who are applying for visas, just like tourist visas or whatever it is, that you are very aware of whatever the agent that you're using to prepare your application put in your application. Okay, it's very important that you understand what is being there and that that information is accurate. And it's very important that when you speak with a consulate officer, that you're very clear on your answers, because right now we're dealing with a PC that came to us, and it's just very unfortunate that they have this notice of intent to deny based on something not in their application, because they were very truthful in their application, but the way it was presented in the consulate, the consular officer misconstrued it, and put it, his notes in writing, and now he's in a bona fide marriage, everything is wonderful, and now that is what his problem is, what the consular officer wrote. So again, these are things that these are things, and why we say, schedule consults, because in these consultations, we want to talk about that. What did you apply for? Many people here, if you've ever been come to consult with me, or, or your current client, like one of the questions I ask people generally is, well, what did you write in your tourist visa? Were you married? Were you single? What did you say you were coming for? Because, it's not just putting together. I mean, I feel like you guys hear this all the time. It's not just putting together an application. Oh, I'm married to a U.S. citizen. Let's just gather good faith evidence and we're ready. We're good to go. There's a lot of all those things that come up. So this is a case where they have a lovely, genuine marriage with all of this good faith evidence, but now what is haunting them is their consulate stuff. So it is important. If you've never ordered a FOIA for yourself, you should get a FOIA. Get a FOIA and ask for your entire alien file. Ask for your B1, B2 application, your H2B application, your F1 application, whatever it is that you've submitted to immigration, so you can review those things to make sure it is consistent, with whatever it is that you're planning to apply for, and that you can connect the dots. Because, if you're not able to connect the dots, or, if there's no consistency, or there's an opportunity for it to be misunderstood, you have to be ready to explain it. And that's why I always say, like, when we submit applications, my goal is that if I'm looking at someone's packet, is that if there is anything in this packet that I have a question about as their attorney, it means that an officer is going to have the same question. And because an officer is going to have the same question, we must address and answer that question before they even have the opportunity to ask for it. Like, let's put it there. If you're sending pictures or whatever it is, and they're already going to have a question about, well, who's in this picture? Where's this picture from? Who's the one that wrote this? Where's the one? Put that information there. Okay. Someone is asking, so let's just jump right into the questions. And again, if you find this my lives helpful and you want to schedule a consultation, hit and you can comment yes, and someone will reach out to you after the call. Someone is asking, can a 2-year green card holder who is divorced still travel outside the country? Yes, divorce does not stop you from being a green card holder. What it just means is that you're going to need to file an I-751 application if you've not already filed one. Okay, so when you file your I-751, you want to make sure that you are requesting a waiver for divorce. Again, I don't know your personal circumstances without a consultation, so I'm giving you very generic information. I don't know your immigration history. I don't know your criminal history. I don't know what challenges you had when you were getting your initial application. Did you have a Stokes interview before they approved you? So again, guys, like I say, I can give you basic answers, but I really don't know your history. But a typical green card holder can travel without any single flaw, without any single issue. But if there's any single thing that's a but and, you always want to check, okay? Okay, so let's see. Princess says, you're the best. It's almost time for me to come back from my citizenship. Yay, this is one of our former clients. Yes, we can't wait to see you here for your citizenship. I'm so happy for you and to see how much you are thriving. What should I do if my VAWA case was denied after 4 years? This is a good question. If your VAWA case or any case for that matter was denied, the first thing you want to do within the first 30 days of denial is that you want to reach out to an attorney, schedule a consultation so that you can both dissect what the issues were that caused your denial. Because sometimes when we look at the issues, we would have to make a determination. Should the next move be to file an appeal, or should the next move be to refile a case? Because sometimes one is better than the other. In your case, for instance, as a VAWA applicant, let me give you an example. You said that your VAWA case has been pending for 4 years and your VAWA case was denied. The first thing I'm going to want to know is, number one, are you still with your spouse? When did you divorce your spouse? Has it been less than 2 years since you and your spouse got divorced, if you're divorced? Because I want to know whether we can preserve your rights to refile a new VAWA properly and correctly. And then also, I want to see what the basis of the denial is. Because if the denial is something where we can overcome every potential issue by filing an appeal, then an appeal will be better. If you're no longer married and your marriage has been more than 2 years since you divorced, your only option would be an appeal if you meet the requirements of file an appeal. Because remember, again, you can't just file an appeal just because you feel like filing an appeal. You have to have a basis of which you're requesting reconsideration or reopening of your case. So there are a lot of variables, and this is for you, Alicia. I'm happy to schedule a consultation with you, schedule one with my office, and then we can go over your denial, upload your denial, and we'll go over it, okay? So Anthony says, trust me, guys, a consultation is everything. It sets the bar and you'll feel so much more comfortable regardless of your situation. First class. Thank you so much. I really appreciate that. David says, good morning, Miss Aisha. You're truly the best in what you do. Thank you, guys. Somebody else says on YouTube says, if you have a pending removal of condition, and soon to go through divorce, will I need to withdraw the file jointly, or can I keep the same and change it to a waiver? Again, this is a very good question. The question basically is that if you have a 751 where you filed a joint filing with your spouse and now you're going through a divorce, do you need to withdraw that case, or can you just request a waiver? So again, in this scenario, you don't need to withdraw the 751. You'll request an amendment to your application to request a waiver, and you will have to present the legal basis on which you're requesting the waiver and evidence of that. In a divorce situation, of course, one, you have to have a properly executed divorce, meaning that your divorce has to be finalized before you request that amendment. But also, the most important thing in a divorce situation is good faith marriage. I cannot stress that enough. I cannot stress how shocking it is actually to see so many people come to consult, wanting to file for removal of condition, and you ask them, okay, well, what do y'all have? And they have nothing. I mean, I know that sometimes there are circumstances in which people don't have anything, but these are people who claim to be in a joint marriage and things are wonderful and everything is good, or whatever it is, but yet they don't, they don't have anything. So if you're filing a joint filing, you better try to get some evidence with your joint spouse. It's one thing if you're saying that your spouse is abusive, or you're requesting a waiver for divorce because your spouse is doing X, Y, and Z to explain the lack of what you have. but you know, make sure you have all that stuff. Okay. I want to address this question. Someone says, "Good morning, Attorney Aisha. The office keeps rescheduling my appointment with you. No one calls unless I call to find out. I want to deal with you, not Attorney Stacy. I've already paid. This is the second time." So I'm not really sure, Khadijah, what the situation is with you, because this is my first time hearing your name. Sometimes, my consults might have to be rescheduled because I might have an unexpected USCIS interview, or something else that requires me to be there in present for my clients. Attorney Stacy is a very, very good attorney, and whether it's me or it's her, I assure you, you're getting the best of either of us. So even if it's Attorney Fatima, Stacy is our lead removal attorney. So it depends on if your case is a removal case. If it is a removal case, you're most likely going to be with Stacy because she's most likely going to be the one in court fighting for you. And I wanted to talk about a result yesterday. I feel like with everything going on, it's important to give good news when we experience good news, especially for people who have complex situations so that they can have hope. So we had this client who came to us 4 years ago, by the way, to file for his son. He was a green card holder. So obviously, if you're a green card holder, when you file for your son has to be in status, at all times while he is, before you file for adjustment of status, and visas have to be current, right? So at the time he came to us, visas were current. So we filed, a family-based green card application, so for the son of, a green card holder. And then one day we're all just minding our business, and then we get a letter from USCIS saying, we are confirming your request to withdraw this application. And so the application has been withdrawn. And we're like, what's happening? Like, we never requested to withdraw it. So I call the father and I'm like, did you withdraw this application? He's like, no. I was like, did your son withdraw the application? He's like, no. So we reached out to USCIS saying, this is your error. This client never withdrew it. And, and the reason why this was so serious was because when the withdrawal came, visas were no longer current, meaning that he would be out of status and he would not be able to adjust his status again. He would have to go back to Jamaica. This is a Jamaican client. He would have to go back to Jamaica, after getting a 601A waiver. So we're not playing about this. Like, this is your error, you must fix it. And so USCIS, they kept ignoring us, saying, we'll send all this requests. Nobody's reaching out to us. We did an ombudsman request saying that this is your error, you must fix it. The ombudsman, reached out to USCIS. But at this point, we're like in 2024. The ombudsman reached out to USCIS. We wrote like a dissertation. And, the thing about what we do, I can't speak for anybody else. What we do is I like things in writing because I like to screen share and document that in my exhibits when we're saying this is what happened, this is what we followed up with, or whatever it is. So basically, we gave the whole narration, we gave all the service request numbers and all of that stuff. The ombudsman said after 90 days, the ombudsman was like, we haven't heard back from them. We're going to keep trying. We're like, you know what? This is actually getting ridiculous. So we sent a threat to sue and file a mandamus. I sent it to the field office director, of clients, field office. And I was like, we will sue you because, this is your error and you must fix it. So, one thing about me is that I don't threaten to sue unless I'm truly planning to sue. And unless you really have a legitimate basis to sue, because sometimes some people want to sue for a decision and they don't necessarily have a good case, or there's a lot going on in their case. And sometimes with that, you end up opening Pandora's box. And that is truly the reality. If you have a basis, there's absolutely no T that hasn't been crossed, or no I that hasn't been crossed, and you've been unfairly, delayed in your process, for sure, you should definitely sue, because that is what it's there for. So we send this threat to sue. Within 30 days, USCIS confirmed that they've reopened the case. They've reopened his 485. So we're like, well, since you reopened his 485, then you need to go ahead and approve his work permit and travel permit so he can at least have those things. But at this point, this was now either 2024 or 2025. So at this point, the visas were no longer current. So, if you know anything about immigration or family preference categories, you know that they have to be processing your case, your visas or your date, your priority date before they can approve you. So, the visas became current, late last year, sorry, or early this year, I think, early this year. And so we reached out in February again, and we're just like, okay, visas are current. When is our client's decision? When is it going to come? When are you going to schedule him for the interview? Whatever, So the next thing, they asked us to send a medical in March. And then yesterday, June 2nd, that's when we got his 10-year green card. So it was a very exciting day for us here at the office, because can you imagine like going through that whole process for 4 years? But that's an example of where, zealous advocacy. So even though it took 4 years, during that time, we opened it, and at least had his work permit and travel permit and his 10-year green card. So sometimes, USCIS does make mistakes, and sometimes you truly should be suing or threatening to sue USCIS based on their error so that they can fix it. So that was something that we were very happy about yesterday. Okay, so let me see. What other questions can I answer? This person says, I have a pending removal of condition, and my spouse is talking about divorce. We'll have to file new removal of condition, or can we keep the same one that's been pending and change it to a waiver? Princess, I definitely recommend scheduling a consultation. Waivers for 751s are very complex, because the first thing you want to do before you're doing an amendment is that we need to see what you first of all put in your original application, because oftentimes when people come to us for a waiver on their 751, there's a lot lacking in their original file. And when there's a lot lacking in your original file, we want to address it at the same time and include those things when we're submitting a waiver. So you want to make sure that you have those two. Okay. So, happy to, schedule a consult with you. But again, guys, it does not matter if, I can be everywhere and everywhere. Like some days I'm literally at USCIS for 4 hours, because that's how long between the drive there, waiting there for like 2 to 3 hours, and then doing the interview and then coming back. Like that's how long it takes. Any attorney here is good enough to do your consultation and qualify you. Whether or not Stacey Fatima does your consultation, I'm the one that finishes your case. I finish every single case in this office, and any of my clients can tell you that. Like I'm the final review. I mean, I have another attorney here who used to work for USCIS. She does the first round of revision and review, and I do the final round, because I'm not putting my name down on anything or signing as a preparer without making sure that the things that I know can disqualify someone are not fixed. So it doesn't really matter. Okay. Okay. Someone says, I have a pending VAWA. What are the chances of the VAWA being approved if your spouse has passed away? Your spouse passing away while your VAWA is pending does not affect your ability to have your VAWA approved. The elements of VAWA is what determines whether or not your VAWA will be approved. As long as you filed for VAWA within 2 years, of the death of your abuser. So let's say your abuser dies before you file for VAWA. You want to make sure that that VAWA is filed before the 2-year anniversary of the death. Same thing if you're divorced. If you divorce them before you file for VAWA, you want to submit that VAWA before the divorce is 2 years old. The most important thing for a VAWA approval is meeting the elements, the requirements of VAWA. One, that you're married to, in your case, a good faith marriage to a U.S. citizen or a green card holder. Number 2, that you have cohabitation. This is the number one thing I see that causes people RFEs, notices of intent to deny, and denial. Cohabitation, proving that you and your spouse live together at some point after marriage. Before December of 2025, the requirement used to be prior to and including marriage. Like it could be before marriage or after marriage. The current administration changed that, I think on December 16th or so of 2025, to the requirement now being cohabitation must be after marriage to have the qualifying relationship for VAWA. The other thing is that you must prove that there is or there was extreme cruelty and abuse at some point during that marriage, okay? And then the last element is that you have to prove that you're a person of good moral character. The requirement typically when you are submitting for a VAWA application is 3-year good moral character. They can choose to go as far back as they want, but in order to determine for a prima facie determination, we want to go back at least 3 years. So if you've not been in the country, so let's say you came to America in 2024 and you're filing for VAWA in 2026, yes, we can run an FBI fingerprint on you, and it will say that you're clear, but you're missing 2023. So USCIS is going to want clearance, police clearance from wherever like you came from, like so whatever country you're from, for at minimum 2024 through when you entered the United States, because they know that at whatever point you enter the United States, they can do a fingerprinting and get that information. So as long as you meet those elements, you will typically be eligible for VAWA. So that is the key. So obviously meeting the elements is not just you stating your evidence, and your personal statement has to support that you meet that. Usually, again, during the consultations, these are some of the questions that we ask you. Sometimes people don't like to give you the information, or they're like, wow, I didn't know that you were going to ask me all this in the detail. But literally, that is the point of a consultation. I can't imagine like scheduling a consult with a lawyer where you don't want them to ask you these questions, or you don't want them to make sure that you're qualified, So I have had people that are sad, if I said, we can't represent you because you don't meet the elements. And it's not because we don't want to represent you, but, I truly believe in integrity in what I do. And I think that when you present your best case forward, not only does it make a difference for you, it also impacts every single client of mine. Like, as opposed to bringing frivolous cases just because you feel like it, I am trauma informed, so I don't dismiss people's abuse or whatever it is that they experience. But it is important that you're able to explain and articulate that, because if I'm asking you that question, USCIS will be asking you the same question. Again, if you found this helpful, you have follow-up questions. I know there were a lot of questions I wasn't able to get to. Comment yes, or schedule a consultation. That is the best way to get your question answered. Call our office. I'm not, someone says, hey, what are you selling? I'm not selling anything. So you can feel free to jump off the live. If this live is not for you, I got to jump off right now, but I will talk to you guys later. I hope you guys have an amazing day. And I'll answer one last question. This person is saying, are you seeing any movement from USCIS applications from the formerly banned countries? Again, remember, it's only been 24 hours that they've had to work since the court order on Friday. So I would say that it's still really early. Let's see what happens through the rest of the week. And then, we're tracking it. We're tracking all 39 countries. You guys know me, like once there's anything new, I post it here. And the reason why I like to put the countries is so you can find your country there and see what it is that they're approving for your country. So as soon as I see any needle moving, I will definitely let you guys know. All right, guys, bye. Have a great day.